counsel.
Thank you.
SJC-11282, Depianti versus Danforth.
All set? All right, let's proceed.
Good morning, Chief Justice and Justices. My name is Shannon List-Riordan. I represent the plaintiffs in this matter. 4 years ago, in the case of De Fiore versus American Airlines, this court said that it would not sanction the use by employers of special contracts to evade their liability under the TIPS law. In that case, a large national actor, American Airlines, tried to lay blame for its policy that it had developed on a smaller intermediate entity that directly contracted with and supervised the workers and carried out the policy that was Americans' creation. Now, increasingly, the latest way that we have seen companies attempt to skirt their obligations under the wage laws is by creating a layer of insulation between themselves and the workers. The court should take this opportunity to say that such a multi-tier structure is not a defense, and it does not just apply to the TIPS law as in De Fiore versus American. The difference between this case and De Fiore is that this is a case involving independent contractor misclassification rather than a TIPS law case.
Could I just...
And the difference...
Go ahead.
And the difference between this case and this court's 2006 decision in Coverall North America versus Division of Unemployment Assistance and this court's 2011 decision in Awua versus Coverall is that here the company has carried out the same scheme but with a multi-layer system in which the defendant tries to point the blame at a smaller entity that carried out the very scheme and structure that JanPro International created.
My question, because it really wasn't before us in the 2011 Awua case, is Mr. Depianti has employees, correct?
Well, JanPro says that Mr. Depianti has employees. Mr. Depianti had he did cleaning work, and he had other people help him do cleaning work, and it's not uncommon in the wage and hour field for companies.
I'm not saying it's uncommon, but I'm just trying to figure out, so it sounds like they work for him. They could sue him for violations of the Wage Act?
Well, JanPro would like you to believe that. That issue is not before the court, whether or not those people who worked with Depianti and he had to share his paycheck around were actually employees of JanPro themselves. That issue is not before you, but it's emblematic of this broader issue that we're seeing in a number of industries that skirt wage and hour violations by creating these layers. And so...
Well, corporate America. I mean, you do create corporates for purposes of shielding from liability. You sell your trademark or the rights to use your trademark to some other corporate entity that then markets it. I mean, that's not a scheme. That's called how you construct business relationships.
Well, in Massachusetts, we have very strict wage laws, which this court has said repeatedly, companies may not create special contracts to avoid workers being paid under the wage laws.
Where's the special contract here?
The only difference between this case and the 2006 Coverall decision that this court decided is that JanPro International created a contract, just as American Airlines did with G2 back in the De Fiore
Contracted
case.
with another company.
Contracted with another company to implement its scheme, exactly as American did with G2
Call it
Secure
a
Staff.
scheme, but it's actually franchising.
Well,
Franchises exist all over the country in lots of different shapes and forms. They're not schemes. They're franchise relationships.
yes, but there's nothing in the Massachusetts wage law that creates some special exception for companies that call themselves franchises. As this court recognized in 2006 in finding that a Coverall, quote, franchisee was actually an employee entitled to unemployment benefits under the third prong of the unemployment statute, which is identical to the third prong of 148B. So just for JanPro and other companies that call themselves franchise companies have basically said, you can't apply the wage laws to us because we're a franchise. And that gets some kind of special consideration under the wage laws. Now, the legislature did not carve out some special exception for franchises, and in fact, last year, a group of franchise organizations went to the legislature and asked them to carve out a specific exception for franchises in 148B, and the text of the bill that was submitted is in the record, and it was rejected by the legislature. It didn't go anywhere. So there is no basis in the statutory language or good reason for the court in this case to carve out some special exception for franchises, which you've declined to do previously.
Get to the question certified.
Yes.
Do you suggest that the franchisees of BME are actually employees of JanPro, the national company?
That's what we're saying in this case.
That no
Depianti,
contractual relationship with JanPro?
exactly, because in 148B, what the court asked, what the district court asked this court, is does 148B require that there be a contract for service between the employee and the employer in order for there to be misclassification? The answer to that is obviously no.
Obviously no.
Well, in most employment relationships, there's no contract.
An agreement, an arrangement directly between the person for asking that the services be done and the person's doing the services.
Well, there's such an agreement here.
Between JanPro and
Depianti had a written signed contract with an entity called Bradley Marketing, and when asked at his deposition, he said he just knew he worked for JanPro. But he understood. He wore a JanPro uniform. He did cleaning for clients who had gone to a JanPro website and picked out the regional office.
Every employee of McDonald's that wears a McDonald's uniform is an employee of McDonald's America?
Well, Justice Cordy, you don't need to get to that question because that's not the issue before you. The issue we have here is a system in which the workers, the people actually doing the cleaning work, are not anyone's employee and thus don't have any of the social safety nets that employment status is designed to ensure. Unemployment, workers' comp, guaranteed minimum wage, right to overtime, et cetera. The reason you don't need to get to that broader question about whether that would make any employee who works at a McDonald's franchise to be an employee of McDonald's is because they're their employees. And as the Attorney General has said in its advisory, it's going to focus on the situations in which
your clients are employees too, and they have contracts with BME.
It happens quite frequently in the construction industry, the cleaning industry, and all of these industries that exploit workers, immigrant workers in particular, that there's some higher-up company that's actually controlling the situation that claims on paper that there's some intermediate entity that is actually the employer who they can point the finger at if the employee doesn't get paid wages.
Didn't you sue BME? Didn't you settle with BME?
It's arbitrated.
There was an arbitration clause, an arbitrator based solely on the language of the contract that said that Depianti was an independent contractor, said he's an independent contractor, and therefore, Depianti, you have to share the cost of arbitration. He couldn't afford to do that, so that case ended.
The question of whether or not there was a violation of the of 148B, or whether there was a misclassification, that claim had to be tried to an arbitrator?
I'm sorry. In the written agreement between Depianti and BME, there was an arbitration clause. So that's why his claim against BME went to arbitration.
Was it a claim for misclassification? Because wouldn't that be the logical first entity to try to say you've misclassified, you're calling me an independent contractor, and in fact I'm an employee?
It was, and it didn't work. He wasn't able to do anything. And in fact, in this Court's recent decision,
that was the issue. If he had been able to afford it, that would have been the issue that was getting arbitrated. Justice
that would have been, but the bigger issue here is when you have these big national actors, just like in the DeFiore versus American Airline case, setting up a policy and then trying to point the finger at the under-subsidized, smaller intermediate entities who are not going to be able to satisfy judgments when there are wage violations. It was American that created the policy that this Court found would be liable for a TIPS law violation. There's really no difference here where you have JanPro International creating the very policy that Depianti is challenging. In contrast, Justice Cordy, to your McDonald's example, where if For instance, an employee at a McDonald's franchise isn't being paid overtime, but the McDonald's franchisor had nothing to do with the fact that in one store, one employee wasn't being paid overtime. Here, Depianti is challenging the very thing that JanPro International set up, which is a system by which cleaning workers clean office buildings and pay thousands of dollars to do so. They are carrying out the work in the usual course of business of JanPro International. JanPro International advertises itself on its website and in its contracts with its regional so-called master franchises such as Bradley that it is in the commercial cleaning business. So under the plain language of 148B, Depianti is performing work within the usual course of business of JanPro International. And of course, the defendant here, as in similar cases, is going to try to dream up absurd consequences to that plain language, such as that this will end McDonald's in Massachusetts, and it won't. And it just won't, because one point was, we've noted in our briefs, is in some sense these cleaning franchise companies, which have come to this court time and again, are in a sense sui generis. It just really hasn't come up in other cases, in other industries, because typical franchises, as a franchise expert is noted in the record somewhere, Seth Statfield, explained that in a traditional franchise, the revenues flow uphill, not downhill. So in other words, the franchisee interacts with the customers, collects the revenues, and pays a franchise fee up to the franchisor. In these cleaning companies situations, such as the JanPro situation, the company collects the money from the customer and pays the worker something that looks like a paycheck after taking out various deductions.
The company being BME or JanPro?
Well, here it's JanPro International has set up the system in which it requires BME to do this, just like American Airlines with G2. And Depianti, who wore a JanPro uniform to work, and thought that he was working for JanPro, that's what he knew, JanPro. He knew there was a Mr. Bradley who he thought worked for JanPro.
And with whom he signed a contract, presumably.
Well, but once again, this court has said that signing a contract that would exempt an employer from the wage laws is not valid.
Right.
So if JanPro International under Section 148B is Depianti's employer, it makes no difference whether there's some contract that says that Depianti is an independent contractor. It makes no difference whether Depianti signed some contract saying that BME is well, it doesn't say that BME is his employer because it denies that there's an employment relationship. But you look at the actual situation under the wage law. You don't look at what the contracts say.
So are you basically saying this is a structure that is different from McDonald's in Massachusetts? That because
yes.
there's a JPI is the franchisor to BME, and then BME in turn is a franchisor to the plaintiffs like your client.
Well, that's what JanPro International is saying. It's this multi-tiered structure, this multi-layered structure that JanPro, like other companies, are trying to use. This is what we're seeing now in wage and hour law.
McDonald's, because in McDonald's it ends with the franchisee employing the line workers.
Exactly, where there are actually employees who are receiving unemployment, workers' comp, guaranteed minimum wage, all those basic protections. And that's where the Attorney General's office, in interpreting 148B and stating where its enforcement priorities are going to be, is focusing to ensure that workers have that safety net. Here, Depianti and the other workers don't have the safety net. JanPro is responsible for exactly what they're challenging, and it's only pointing to BME based on some contract, some dense contract that that says that the workers are independent contractors. And I just want to point out a couple of things. If in the record, if you go to the JanPro website, it has a listing of locations, all of its regional offices. Record at 800 has JanPro of Eastern Massachusetts. The customer goes to the JanPro website and thinks that they are contracting with JanPro. The JanPro agreement between, JanPro International agreement between itself and its so-called master franchisee gives it total control over the contract between BME and the so-called unit franchisee, such as Depianti. If you look at provision section 14, at appendix at 786, Well, first of all, it says that JanPro is a third-party beneficiary of the franchise agreement between Depianti and BME. And if you look at Section 4.15 on Appendix 774, it says that the franchisor has the right, within its sole discretion, to enforce any provision of a contract between BME and Depianti. So, in other words, JanPro International can fire Depianti, because if JanPro says to BME, fire Depianti, and BME declines or refuses to do so under Section 415, JanPro can do that. So JanPro International has the right to fire.
Now, this case is going to go back to Judge Wolf, and we're supposed to answer questions. As to the question whether a defendant may be liable for employee misclassification, where there was no contract for service between the plaintiff and defendant, you say we should answer precisely what?
No, there is no requirement that there be a contract. Only prong 1 of Section 148B makes any mention of a contract. Prongs 2 and 3 don't. And as, of course, this Court recognized you only need...
No? You think we write back no, and Judge Wolf says, thank you, that's enough guidance for me to... somewhere I thought he said he was hoping for more than that.
He did say he was hoping for more than that, yes. And
so should we say sorry, or should we give him more than that? And if we give him more, what should that more be?
well, the more should be that on the facts of this case, on this record, Depianti is JanPro's International's employee. And if you also look in the record, Judge Wolf said, when he originally said that he was going to certify this case, that he had concerns about his disagreement with the Georgia Court of Appeals conclusion. That was at Appendix 1150. I believe what would be proper for this Court to do is look at this record, not think of all of those absurd hypotheticals that JanPro and other companies would like the Court to worry about. Focus on this record. These workers, they look like employees, they smell like employees, they act like employees, but they're not being treated as anyone's employee, thus they're not getting any basic rights to wages, unemployment, et cetera. There's really no difference here between this case and the Coverall 2006 case. Depianti can't wear his own hat. He was wearing a JanPro uniform. Any new customers are going to be JanPro customers.
But in Coverall, that was Judge Young who made that decision.
Actually, I'm going back to the unemployment case that was in 2006 before this Court. That was on prong 3. This Court found that Coverall hadn't proven that a franchisee was an independent contractor. And then for Coverall, we have both Judge Young finding right in Awua under prong 2, and also Judge Wolf in the Janiking case, which is in this record, found as well under prong 2 that Janiking was an employer, and Janiking also had a similar so-called multi-tier structure, although it didn't emphasize as much as JanPro has the distinctness between those different tiers. But Judge Wolf granted summary judgment to the plaintiffs in the Janiking case under more detailed reasoning even than Judge Young had in the Coverall case.
So you're basically saying we should decide the case for him, as opposed to providing some standards as to when you may be deemed when you're liable for employment classification without having a contract.
Well, the concern that Judge Wolf stated was that here there is a contract, a written contract between Depianti and Bradley, and because of that, he was concerned that because there's no written agreement between Depianti and JanPro International, that might mean that Depianti could only look to Bradley as the employer. So that's why he certified the question, is it necessary to have a contract? What I'm saying is that there are employment relationships ubiquitously. There are employment relationships that aren't reduced to writing, but there are understandings of one person is going to work for a company, is going to provide services for a company, and there's no basis in the statutory language to import a requirement that there be a written agreement.
Does it have to be a written agreement or any kind of
It doesn't say
agreement?
contract. I mean, it doesn't say written agreement here. Contract.
Well,
It can be oral.
Well, Judge Wolf's concern was based on the fact that here there was a written agreement between Depianti and JanPro International. But as we pointed out, JanPro International, between Depianti and BME, JanPro International is a third-party beneficiary to that contract. And as I just pointed out, under JanPro International's contract with BME, it has the right to enforce the contract between BME and Depianti. So on these facts, The court doesn't have to get into thinking about what this is going to do for the McDonald's of the world, where the workers behind the counter are someone's employee. On these facts, there is no reason why 148B shouldn't be applied as written, and Depianti found, just as in Coverall, just as in Janiking, just as in the 2006 Coverall decision, that Depianti is the employee of JanPro.
Thank you, counsel.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Jeffrey Rosen, and I represent JanPro Franchising International. I would like to touch briefly upon certified questions 1 and 2, and then move to certified question 3. For certified question 1, I wanted to highlight for the Court.
Is that the everybody's using these in different numbers, in different orders. Could we just be clear about the substance of which question we're talking about? Are you talking about the misclassification question as 1?
Justice Lank, I'm talking about the administrative filing requirement with the Attorney General's office.
All right. In what order did Judge Wolf?
That was his certified
Administrative remedies
question
is
1
number
as well.
1?
BBC.
Okay.
My apologies for that.
Okay.
We cite the Ryan versus Holy Donut case in our opening brief at page 50, and that is a case under Chapter 151B, Section 9, and it specifically finds that it is a jurisdictional prerequisite to suit to file first at the MCAD.
But
to the
as
point
the
that-
plaintiff points out, there are a lot of differences between the reason for filing before the MCAD and the reason for giving notice to the AG.
Your Honor, I submit that the reasons are exactly the same, and I think that the language in the statutes is borrowed exactly from Chapter 151B, Section 9, and this Court's precedent is clear that when the legislature borrows language, particularly this close in time to that language being finalized in Chapter 151B, Section 9, that it has the same purpose in mind. This Court denied further appellate review of the Ryan versus Holy Donut case on November 29th. And I just wanted to note that in there, the court, in the appeals court, the lower court stated that she was not entitled to bypass the mandatory and preferred procedure. This omission creates a conclusive affirmative defense.
But in the MCAD context, the MCAD serves as an adjudicatory body. They can take jurisdiction over the case. Whereas in the context of this statute, the Attorney General is an enforcer and doesn't have to enforce. Aren't there a lot of differences between the two?
Your Honor, I think that the interests are stronger of the Commonwealth here to have notice of that claim first, because this is a statute that carries criminal penalties. This is a statute that for over 100 years, sorry, Your Honor.
Go ahead.
This was a statute that was for over 100 years exclusively a matter of government enforcement. And that language was borrowed with the intent in mind of the way Chapter 151B was being interpreted.
Did you say it was the case you just cited, Ryan?
Ryan versus Holy Donut.
That it was an affirmative defense?
The appeals court says that the plaintiff, who did not go to the MCAD first, was not entitled to bypass the mandatory and preferred procedure of going to the MCAD first. This omission creates a conclusive affirmative defense. Here, we raised an affirmative defense that Mr. Depianti did not file first with the Attorney General's office. Judge Wolf, as this Court is aware, has found that argument was preliminarily waived. We don't think it was permanently waived. We think that this is a jurisdictional issue. We think that this Court should answer question 1, that this is a jurisdictional issue. But even if it's not, even if it's a waivable defense, we've raised this as an affirmative defense. We're entitled to raise it again. The parties and Judge Wolf are going to need guidance on what happens next if this is not a jurisdictional issue.
Well, if it's waivable and he said you waived it, what do we have to add to that?
Well, because Your Honor's opinion in Vassus, which is cited in our opening brief, says that once an issue is part of a pleading, it can be proved any time up through trial. So if Judge Wolf continues to find that, it's going to be an issue before the First Circuit. And that finding of waiver, is subject to doubt. So we think that Your Honor should weigh in on that issue in light of the procedural history here if it's not jurisdictional. And that's what I wanted to mention on certified.
And what's the consequence of the fact that they have gone now to the AG, and the AG has said, go ahead?
It's serious consequences here because the complaint that was actually filed with the Attorney General's office says that the harm occurred from 2004 to 2006. And so if this defense is dispositive to the dismissal of the claim, the claim is now time barred.
But
in
if
our
we
view.
say it's not a jurisdictional issue, it's merely an exhaustion of administrative remedies, then it becomes discretionary with the federal court.
Your Honor, and I think that there's a serious issue with that discretion, considering that it is an affirmative defense. We had no obligation to move for summary judgment. And, Your Honor, the issue was fully briefed, and there's been no ruling on summary
This
judgment.
ruling, we can't interfere with that.
I'll move on, Your Honors. But that's what we request you to do. I think you can, and I think you have, Your Honor. Just to finish that point, I think that in De Fiori versus American Airlines, you disagreed with Judge Young's ruling on the motion for a new trial, and you could do the same thing here. On certified question 2, what is the appropriate standard for vicarious liability in the tort context? That's a question Judge Wolf certified to deal with the Chapter 93A and the misrepresentation claims. We ask in our brief for this court to follow the Curl versus Dennis Rasmussen rationale that is analyzed extensively by the Wisconsin Supreme Court and has been followed by numerous courts across the country. We think,
Mentality rule?
yes, we think it's a fair standard. We haven't been able to locate it here with this court, and we think that it should be followed.
And what is,
What are the consequences of following that rule in this kind of case?
So here I think Mr. Depianti would have to say, prove, and Judge Wolf would have to find that there is harm occurring here. And the question would be, what is that harm? Mr. Depianti's allegation of harm is that he didn't have his full franchise plan for long enough or for a satisfactory period of time. So the question would be, is there a misrepresentation in those facts, or is there a Chapter 93A violation in those facts? And then the second question would be, what is the instrumentality of that harm? What is it? And is the instrumentality of that harm Bradley Marketing's offering of accounts, accounts being taken away, the reasons for those? And then the third question would be, did Janpro Franchising International control the instrumentality of that harm? Those would be the three questions that would need to be answered under that standard. We submit that that's a fair standard, it's fair to both parties, and that it would be, and it is a majority rule, and it should be applied in this Commonwealth as well.
We don't have to decide. I mean, let me ask this. Judge Wolf isn't asking us to decide what the instrumentality is here, just whether or not we're going to adopt that rule, essentially.
That's correct, Justice Cordy.
and I'm sorry, what does instrumentality mean again?
Basically, what is causing the harm?
What is causing the harm, or who is causing the harm?
Well, I think it's both. I mean, if Mr. Depianti is being harmed because his accounts are supposedly being taken away, what is the hand that is causing that? Is it the way Bradley Marketing offers accounts? Is it the way that Bradley Marketing determines that an account or how to verify a customer complaint to the point that the customer chosen themselves to cancel the account?
Or is it the structure itself?
Exactly.
And the
Is it
structure itself might well be something that, under the instrumentality rule, is controlled by Janpro.
It could be, Your Honors, but it's important to distinguish, if you write this opinion, it's important to distinguish that there are going to be controls in Janpro Franchising International's, JPI's contract with BME. There are going to be controls there. But those controls don't establish that they're having day-to-day control over the instrumentality of the harm. And so when the Curl case speaks of this kind of control, they speak to control over the day-to-day operations of the instrumentality. So Janpro Franchising International, if they got involved in customer offerings, if they got involved in customer complaints, if Janpro Franchising International got involved in Bradley's decisions about to remove accounts, then that would be something that they could be directly involved in. For example, if McDonald's tells people how to make a hamburger, but there's a rock in somebody's hamburger, and they did it specifically according to McDonald's plan and using McDonald's processes, then that could be an issue of tort liability for McDonald's corporate.
Okay, but even that would not be day-to-day operation. I mean, maybe periodically they'll come by to survey the franchise and make sure they're following procedures, but that's not day-to-day.
Well, exactly, but they have said to the franchisee, here's where you buy your hamburgers, here's how they are produced, and here's where you should get them from. And so they're involved in that process.
So it's control or right to control over the day-to-day operations of this instrumentality.
That's true, except we have to be delicate, I think, when we talk about rights of control, the day-to-day instrumentality, because like I said, the franchise agreement will have rights to control that. They need to have that because franchisors are supposed to control the operations and the trademark and protect it and build it. And that's part of being a franchise.
Isn't part, I thought, but I don't know this record very well yet. I thought part of the, since the issue is whether the Mr. Depianti and people like him have been misclassified, that part of the harm would be I'm not getting treated as an employee. I don't have workers' comp. I don't, all those things. Isn't that so?
No, that's not correct, Your Honor. Judge Wolf is distinguishing certified question 2 goes to the misrepresentation claim.
So it's the 93A claim?
And the 93A claim. That's correct, Your
It
Honor.
only goes to the 93A.
That's right, and he was specific about that in the record, and it's cited in our brief as
Okay,
honors.
I mean, I know that's how it gets argued, but so when you're talking about harm, it's only in that context.
That's correct, Your
It's
Honor.
not harm vis-a-vis employee
That's
versus, I'm sorry.
Independent contract.
Yeah, okay.
That's correct.
This is focused purely on the churning? There's a problem for us to be answering questions in the abstract. So, because here we're dealing with a case in which your sister says this is not a franchise at all. And now we're being asked a question which assumes it is a franchise. What specifically is the issue that we're addressing in the context of what? Is it purely churning or is it something else?
Well, Mr. Depianti's sole allegation of wrongdoing is that he didn't have accounts for a sufficient period of time at a sufficient level of revenue. That's his allegation of harm in the tort Chapter 93A context.
So that includes churning, doesn't it?
I don't like that phrase. I guess as my sister has used it, it would include that. There hasn't been churning of his accounts.
Yeah, I don't mean to be painting some pejorative picture, but it sounds like substantively that's the allegation.
That is
That taking them away to use somewhere else.
theoretically, although there's no proof in the record that they were taken away to be used somewhere else. That's still just an allegation.
Right, but we're just answering questions. We're not deciding the case. That's for Judge Wolf to do.
Exactly, Your Honor.
All right, let's turn to the third.
Move to the third question. Mr. Depianti here is the McDonald's franchisee. He is the entity that has employees. He is the franchisee. He is the person responsible for complying with the wage laws. Now, it is a creative and crafty argument to say that he's actually an employee of the entity that sold him the franchise. He doesn't allege that he was sold the franchise in violation or have any record evidence of it, that he was sold the franchise in violation of any franchise laws.
In the contract between BME and the plaintiff, is there any obligation placed on the plaintiff to comply with wage laws, or is there any mention of the wage laws?
There is, Your Honor. In the disclosure document that Bradley Marketing sent to Mr. Depianti before he bought his franchise, and in the franchise agreement, there is this obligation. Mr. Depianti, and the notion that a franchise agreement is a special contract to evade the wage law, doesn't that assume that Bradley has somehow evaded the wage law? There's no evidence of that.
But
In
again,
fact,
let me ask you the same question I asked your sister. We have a question that the judge has given us. Whether a defendant may be liable for employee misclassification where there was no contract for service between the plaintiff and defendant. Answer?
there does need to be a contract.
Written, or can it be oral?
We feel that any agreement constitutes a contract. So yes, written or oral. Express,
Okay.
or as I said to
And-
Judge Wolf, implied.
Agreement for services.
An agreement for services. In fact, the very nature of the independent contractor statute is to ask this question. That person, that entity that you've engaged to perform service for you, are they truly an independent contractor, or are they actually your employee? So the whole intent of the statute is an engagement of service between those two entities. The text of the statute speaks of there need to be a contract. There needs to be a contract for review.
But that's
It
only
doesn't
as to
need be
prong
written.
one, right?
That's to prong one, but when you read the statute as a whole, and when you read the other provisions so as not to be inconsistent with each other, you arrive at the conclusion, and that you look at other language, such as the fact that the statute's drafted in the conjunctive, and you look at the fact that every section of the statute talks about performance of service for the employing unit, that the statute doesn't say that, but this court's precedent says that in Summers and in Athol. This court talks about analyzing the ABC test against the employing unit.
Okay, and
Can I ask you, JanPro is a third-party beneficiary and also has the right to enforce this contract. Doesn't that make them a party to the contract?
It does not, Your Honor. It gives them the standard rights that a third-party beneficiary has to a contract. The motorsport engineering case cited in our brief is such that that party is not allowed to be sued. Now, we propose that doesn't mean that every entity that wants to evade the laws is somehow going to be subject to escape liability under the statute. What we propose is a test of corporate veil piercing, and that if you need to pierce, if you need to look away from that entity that does engage the services, and you need to look at a third party, let's apply that time-tested analysis that this court has substantial precedent on. And if I might, one more thing before we part. Judge Wolf clearly wants guidance on the three prongs of the statute. The usual course of business prong, which my sister focuses on heavily, is such that we should define, we ask this court to define what that usual course of business is. And usual is something that happens on a day-to-day basis, habitually and regularly. We cite a dictionary definition for that. And we ask that this court look at the day-to-day operations of JanPro Franchising International and the day-to-day operations of Depianti and ask whether the overlap that's there, because there's going to be overlap. There's going to be overlap that's required of franchisors when they're marketing the same brand. There's going to be overlap that's required when they might have to step in to BME's shoes and give Depianti some support. That might happen in the context of a franchise relationship. But let's make sure that those day-to-day operations don't overlap more than reasonably necessary to cause JanPro Franchising International's usual course of business to be the same as Depianti's. And let's do the same with the other parts of the test, too. If there's control under the contract, if there's control in fact, is it more than reasonably necessary to protect a franchisor's brand or trademark and promote its goodwill? Is it more than reasonably necessary? And is a franchise in and of itself an independent business for Part C of the ABC test? In fact, they are buying an independent business. They're buying a franchise. When you buy a McDonald's, you're buying a job as the CEO of the McDonald's that's in your hometown. That's your job. You get to buy a job as a CEO, and you get to employ people.
All right, thank you very much. We'll take a brief recess.